Thanks for that, everyone. Now we're going to move on to the main assessment area, where we're going to look into what happens at the final case plan and what we assess and what the common issues are at the final assessment stage. I'm going to hand you back over to Anthony to go through that.
Thank you, John. I'm going to take you through some of the main areas that crop up where we need to go into a little bit more detail because they often need a little bit more explanation. So the first area I'm going to look at is main hearings. And the question often is, what is a main hearing? Well, for the purposes of calculation of which events model it is, whether it's more than 10 days or 10 days or under, it's a main hearing is a hearing at which the substantive issues in the case are going to be determined. So that is the definition of a main hearing. So a case management hearing does not count as a main hearing. I don't know whether Rebecca, Chris, Scott, you want to come in here to share experiences around this for your purposes at all?
I can start. For main hearings, the only two bits I would add would be reading days. You've got to remember, if you've got an 11-day case and day one's a reading day, it doesn't escape into events. It will remain within FGF it's for two counsel for two counsel cases, or FAS if it's a single counsel case. And the same also would mostly apply for written submissions, even though they can be paid differently for single counsel and two counsel that can be differently paid. They still don't count towards the escape. I know we will cover written submissions later on, so I'll stop there. But that's what I'll just bring up is reading days are one of the main things that I usually see where somebody will say, oh, we had a reading day. Well, it doesn't count towards the estimate, even if it is listed for 11 days. I'll pass over to Scott now, because I know obviously he'll most probably have something to say on main hearing days as well.
Yeah, I think main hearing days is one of those things that can catch people out, especially when they change. Because if a case falls below the more than 10 days limit for counsel, it will revert to FAS. And that's if the timetable is changed more than 5 working days before the main hearing is due to start. So it's one of those things that you could have a case plan, which is all been calculated on events, and you've got a 15-day composite hearing coming up, and 2 weeks before there's a PHR, and that reduces it to 5 days. That is now remunerated at FAS for counsel, so that can very quickly change your case plan. In terms of your cost limits, it's not going to matter because you'll have potentially had a cost plan agreed for far more than that. But for counsel, it will mean their fees change rapidly, so it's something you need to sort of be aware of for when the main hearing changes.
Yeah, I would also add to that as well, Scott, because also be aware that if you have two counsel high cost case and you have a single counsel high cost case, if they both fall below 10 plus days, be aware that there are different schemes that are applied. If you're single counsel, it becomes family advocacy scheme. If it's two counsel silk, it becomes family graduated fee scheme. So there's another thing to remember when cases possibly fall below the 10 plus days. And I know that also creates a couple of issues along the way.
Yeah, and I think also that the understanding that hearings that have taken place before the case has been registered as VHCC, you can't claim underruns as part of and increase the main hearing length based on, well, it was listed for 8 days, it only went for 5, but now we've registered as VHCC, it's a 5-day hearing for those purposes, so it doesn't count, and you can't claim the underruns either. They're unclaimable.
And that's exactly right as well. I think as well, there's other added to it as well, where you have a single counsel case that you then get authority for a silk to come along. It goes over 10 plus days, and then it starts affecting how you can claim advocates meetings, how you can claim conferences, all those sort of bits and pieces come in. There are pitfalls on main hearings. There are quite a few, mostly too many to mention, but they are the main ones to be aware of, that when it falls below or goes above, it will have an effect depending on if you have prior authority or you don't. And I know you've mostly come across that as well, as most probably Rebecca has as well.
And I think when you look at reading days, sorry, going back to the beginning again, reading days, whilst they won't count as an event if they are completely a reading day. If the judge at 2 o'clock says, right, I want all advocates in, it then becomes an event and a hearing day. So quite often you'll find that council's clerks will say, can you put it on your case plan as an event? Because it might be an event for the purposes of increasing the cost limit. It may well be an event. If it then isn't an event, if the judge decides they don't want anybody in, then it will be reduced at the final case plan stage. It's not a problem. But if we haven't allowed for it in the case plan in the first instance, it can cause a problem, and we could be an event short when we're trying to claim a payment on account. So it's one of those weirdities of reading day where it's Schrodinger's event. It's both a hearing day and it's not a hearing day. So it's one of those things to just be aware of.
I'm going to sort of move on to written submissions. Chris has already mentioned this aspect already. I think the most important thing to know about written submissions is that when the events models were created, written submissions were taken as part of the preparation of the case. So they weren't treated as a separate item from preparation. They were taken as preparation of the entire case. Now, there was one circumstance where a question was asked of the LAA many years ago now, and it was in relation to a case that was of more than 10 days main hearing. And it was on day, I think, about 13 out of 15. And the judge had said, I'm setting aside the next day as a day for written submissions. And the question was posed to the LAA at that stage saying, okay, this is what has happened. Will you pay us an event for this day? And rather quickly, and without really reflecting on the fact that written submissions form part of preparation, so the actual answer ought to have been to say, it won't count as an event day for everybody, but of course it will count as an underrun for everybody in that situation. What the LAA actually said rather quickly was for the person preparing that written submission, they will have a full event, but that it would be an underrun for everybody else. That is the situation, and it's the one situation where written submissions have qualified for an event going forward. And it's in no other situation has a written submission count for an event. So if, for example, you've got a court listing of 15 days, and on day 15, the judge says, tomorrow, which would otherwise have been day 16 maybe, but is after the original listing of the hearing, the court said, I want you to go and do your written submissions tomorrow, then in that situation, there would be no event fee payable. In fact, there wouldn't be an underrun payable in that situation, because essentially it's just the preparation of the case. And that is the way that the written submissions have been treated. That has been attempts have been made to set that out in the guidance. It is there, but it does require a little bit of reading to understand that as the position. But it's the position that's been applied consistently by the LAA. Chris, Scott, Rebecca, by all means come in at this point and contribute to this particular area, because I'm sure you've got observations.
I mean, I think it's very clear now. I think it's very clear in the guidance, and it should be pretty clear now to most clerks who are doing bills. Very simply, if your written submissions are ordered and they're ordered within the original judicial listed time, and they exceed 10 plus days, obviously, then you will be paid an underrun to one of the council, in two council cases, to one of the council will get a full event and the other one will get an underrun. For my part, if you're a cost charge person, or if you're a solicitor and you're asked this question by a clerk, you can 100% say, if it hasn't fallen within the judicial reading day, you're not getting it. And there's no point saying, put it in anyway, because it will be rejected back, and it will just again slow down the whole case plan procedure, which will slow down guests getting paid. It is very clear. And I think, from my knowledge of sitting in a room 20 years ago, listening to how events is going to work, it has changed and it's evolved, but this is the clearest it's been. So I can't really say much more than that. I mean, I'll pass over to Rebecca and Scott, but from my point of view, there's no point saying, oh, I'll just check out and see, possibly they might let me have it. It won't happen. So that's my views on it, Anthony.
Yeah,
Thank
and I
you.
think so, in a bit of crossover between that and when we were talking about advocates meetings earlier, and where a case changes from single counsel to two counsel, and the number of advocates meetings allowed can change. Those things and written submissions can be areas where barristers and clerks can get it completely wrong, and it's one, certainly the written submissions one, I always reread the guidance. If I'm ever in doubt, I reread the guidance and make absolutely sure I've claimed it right, and always make sure I've got it the right way around. But I think those are the types of things that can very easily become sticky and become difficult, and you might find a clerk saying, oh, as Chris said, just stick it in, it'll be all right. Yeah, just claim it, it's all right. The LA allow it. No, they're going to allow me an extra conference, not without justification, not without, and not unless it's exceptional circumstances, but they're not going to allow 6 advocates meetings before fact finding in a two counsel case. It's just not going to happen. So don't try it on. Don't try and claim submissions for every advocate in the case. It just won't work. So if a clerk is putting that pressure on you, push back and say, no, read the regs, here they are. I think that's a key thing.
I think that's exactly right, Scott, to be honest with you, because it will just, it will just slow things down. I would add just as well, if you are claiming written submissions, remember to get it put in the order. So that's just one other slight point, because if it's not in the order, even if it happens to occur within the judicial reading day, within the judicial time estimate, apologies, then the LLA could quite say, well, it hasn't been ordered, so you can't claim it. So you just both get an underrun. But just because the judge has ordered it outside of the 15-day judicial reading day, for argument's sake, doesn't make it so that the LLA are going to pay you. Please don't fall into that trap of saying the court have ordered it. If they haven't, if it's been ordered outside of the guidance, you're still not going to get it paid. Rebecca,
if it's ordered, yeah, I was just going to back you up basically on that point, and say that if you can claim it, another great idea is to put it in section A in your case plan, in the brief summary. Just include at the bottom an explanation, so straight away the legal aid agency can look at that, understand what you're doing, move it through the process quicker. Just give them a head start.
It's nice and clear, isn't it? Then
really clear. Yeah,
exactly.